Hi there, I'm Alex Hernandez. I'm your personal professor, and today I'm going to talk about what to do when facing a lawsuit. A lot of times we get into this issue of facing a lawsuit, everybody hears you just file for bankruptcy and that's it. But that's not the case. We're going to go over the different steps that are required to make sure that everything goes okay. They don't garnish your wages, levy your bank accounts, or even put a lien on your property. All right, so let's get down to business. If you're filing for bankruptcy, yes, that will stop lawsuits. But here's the question: when are you filing for bankruptcy? Do you have the money now to go forward with the lawyer, or you're planning to do this for one reason or another in the next 3 to 6 months, maybe even longer? How are you going to handle then this civil lawsuit, which they're going to win, and now they're going to start garnishing your wages? Well, the first thing you can do is you see here, you file a response. Now, how to file a response, that's a separate blog post, or just look it up. But basically, you're going to admit and deny certain allegations that are made in the complaint. And then from there, you can also countersue and make your own, basically a counter complaint, counter petition. Now, when that happens, basically, we're talking about a litigated case. Litigated cases have to go through certain processes, and that includes going through the discovery process. The discovery process is basically the exchange of relevant documents. For example, they might say, provide bank statements, they might provide a copy of the contract, they might provide balances, you have to provide pay stubs, etc. All that is standard in any case. I don't care if you're talking about a criminal case or if you're talking about a civil case. That is going to be the standard. Now, besides that, you have to, once you're done with the discovery process, which could take a long time, and that's how you're able to protect yourself because you have this pending, you're going to have to go to either a pretrial conference or a mediation. Now, depending on the jurisdiction that you're at, sometimes a pretrial conference is basically scheduled when the case is filed. So you filed it today, and then there's a date that they automatically put 45 days later where you try to work out the agreement. Sometimes it's best just to go there, work out an agreement, do a minimal payment plan, whatever the number is, $50, $100 a month, just to buy you that time. Think about it. If you're paying $25 every paycheck or $50 every paycheck, that's a lot less than losing 15 to 25% of your paycheck to a wage garnishment. So you just might have to go there, work something out, say, I'll give you $100 a month, we're done. And then 3 months later, you file for bankruptcy. Now, let's assume, and that's really rare, that you can't work out an agreement or that this case should even go to trial. But if it goes to trial, then that'll be the last step, of course. And then you could always, you can even work out an agreement prior to trial. But at that point, it's been such a lengthy time. I mean, at least my experiences, for example, in Miami, that could be 2 or 3 years from the day that it's filed. Just to get a hearing to dismiss your case is another 6 months, 8 months, 10 months. And so I've been able to successfully delay cases that way so that when my client is ready, they can file for bankruptcy. Now, remember, you can't always file for bankruptcy right now and then. There could be multiple reasons why this needs to be put off. But if you have this lawsuit pending and you go through those steps, that's going to protect you. Now, let's say you did file for bankruptcy and you have this lawsuit pending, or they're going to go ahead and garnish your wages. What is the next step? Well, the automatic stay is going to prevent most lawsuits from going forward. I say most lawsuits because, like, a criminal matter is not going to be affected, and cases regarding alimony and child support should not be affected, but judges tend to continue those as well. But here is the key. So you go to the automatic, you get you file your bankruptcy and you have the automatic stay. This is the part that I want you to know. You're not done yet. You should get a suggestion of bankruptcy. You should be able to get that through pacer.gov, which you can see there the status of your case. You can register. I think after like $30 in a month is when they start billing you for documents. So Pacer is the government website. You can see all cases there, but you can follow your bankruptcy website, bankruptcy case as well. If you cannot get the suggestion of bankruptcy there for some reason, then you can get it from the clerk's office. Now, what do you do once you have that suggestion of bankruptcy? Well, you're going to file it in your civil case. That's all you're going to do. You're going to do like a notice of filing is what we typically call it. That's the title, notice of filing, and then you say what you're filing underneath. In this case, a suggestion of bankruptcy. What does that do? It puts everybody on notice that the bankruptcy has been filed to stop the case. Now, from a practical standpoint, let's say you file bankruptcy and 3 days later they take money out of your paycheck. Did you lose that money? No, you get that money back. But time is money. Contacting the creditor or the creditor's attorney, sending them proof, getting this done, getting it reimbursed, this takes time, money, and energy. So it's just easier to file the suggestion of bankruptcy so that it gets filed in a civil case. Remember, whether it's a foreclosure, a car repossession, or a credit card, and that will guarantee that you are protected so that the case stops. All right. So remember, when you file for bankruptcy, I know everybody likes to talk about the automatic stay, but it does not end there. You have to file your suggestion of bankruptcy. That's what's going to keep you protected. Okay? Any questions, as always, feel free to post them in the comment section below. I'll be more than happy to respond to you. You're always welcome to go check out my blog, Bankruptcy.blog, so you can see additional information on all these issues related to bankruptcy and other issues like mortgages, car loans, and student loans. Students, paralegal students that are using my textbook in your course, I hope you're loving the book, right? Give me a shout out there on social media. I worked hard on that baby. Um, but likewise, join the YouTube family here. If you got any questions or comments, you're more than welcome to post them below, and I will respond to you as well. All right. So thank you, everybody. I hope you enjoyed today's video. Remember to like and subscribe. If you've been watching my prior videos, you know I always forget to say that. But look, I'm getting better at this stuff. So like, subscribe, and I do appreciate it. Just like I do all your comments. And the blog is slowly but surely it's picking up. I've been working hard on it, so I hope you like that too. All right, everyone. Take care. I'll see you at the next video.